there were, I think I'm missing a verdict for jury group number.
There we go.
Okay.
Sorry.
All right. Okay, I have 6 verdict forms here. So at this point, if you haven't figured it out yet, normally I don't swear my own witnesses and I don't read verdict forms. But I do read the law, unfortunately. It's the worst part of the job. Okay, let's see here. Does the jury, foreperson of jury number 1, who would that person be?
I don't know that they do which jury they were in. It was the number at the top of your form. But I don't know.
Anyone remember that?
It was actually this group back here. Yeah, I know you guys. The first one that I picked up, the guy in the tan shirt who's Duffy. That's him.
Would the foreperson for that jury please stand up? All right, great. All right, question 1. Has the government proven beyond a reasonable doubt the existence of at least one aggravating factor? The government has proposed 2 such aggravating factors. 1, that there was more than one victim. 2, that the crime was especially heinous. The jury must be unanimous as to what aggravating factor they find to exist. And this jury wrote no. Is that your verdict, sir?
Yes, it is.
Okay, thank you very much for your participation. Okay, the next group of the jurors was 2. I don't know if anyone remembers that. It looks like they also found, oh, very good. All right, our foreperson is standing bravely enough. And they found aggravating factor, was there more than one victim? That jury said no. Was the crime especially heinous? That jury said no. Is that your verdict?
Yes, it is.
Okay, great. There was a jury group number 3.
You guys.
All right. Whoever that was, they also found that there was no aggravating factors in this matter. Now, if you would have noticed, both parties have already stood up. Normally, we will have definitely the defendant stand unless there's a security risk, which oftentimes there is. So, and it's not unusual on serious felony cases that there may be 7, 8, 10 bailiffs in the courtroom for the reading of a verdict. Not unusual at all. All right, the jury number 6, okay, also said no aggravating factors found. Okay, jury number 7. Anyone who remembers 7? Member of 7, our foreperson for jury 7. Okay, has got to start nailing the cross together? No, they found an aggravating factor, but they did not find that the aggravating factors outweighed the mitigating factors, so the life sentence would be, once again, life without the possibility of parole like all the previous verdicts. And lastly, is there an 8? Jury 8, foreperson standing. Thank you. Okay. There was an aggravating factor found to exist. I'm not sure which one was that. Was that the more than one victim or especially heinous?
More than one victim.
Okay. That was found to be true. And did the government prove the aggravation outweighed any mitigating factors?
Sorry, repeat the question.
Right. Did did your jury find that the government proved aggravating circumstances outweighed mitigating factors?
It did not.
Did not. All right. Thank you very much. It looks like our juries are 5 juries, 6 juries, all unanimously agreed that it would be not a death sentence at this point. Defendant, you may sit down.
We're going to take a few minutes. We said we're going until 8:30. We're going to take a few minutes for you to ask questions. We'll have just a brief panel discussion. I'm going to ask Mark and Jeanne to come just stand up here. And I'm going to invite one other guest we have here this evening. Haida Takasugi is going to come too and be able to field questions. She is a public defender here in LA County, and she has defended a number of death penalty cases. And so if you have any questions, we'll have a few minutes for some question and answer. And you can, I think it's small enough we can stand where you are, or there's a mic up here you can come to.
I have a question, kind of a statement too. Isn't any murder a heinous crime? And any murder affects more than one person.
I love what you said. As you heard, I'm a family member of 3 murder victims, and and it's absolutely true that any murder affects more than just the victim. That the ripple effects of that loss go out to everyone who knew and loved them. So I definitely agree with that. And you can also say that any taking of human life is heinous. Any deliberate taking of human life is heinous and merciless, because you're taking this living, breathing human being and snuffing out their life.
So why does a jury have to make that choice? Why is it not in the law?
Sure. In California, there are only certain types of murders that qualify for the death penalty, and they're called special aggravation murders, special circumstance murders, and there's a whole list of them. So by some reason, the law believes that those murders are heinous. So it's not any murder. The California scheme says not all murders qualify for the death penalty. Some of them are multiple murders, torture murder, gang murder, rape murder, robbery murder. Those are some off the top of my head. So there's only certain categories of murders that the government can pursue the death penalty in California.
Yeah, but that category of especially heinous is one of the categories for an aggravating factor. And one of the things that's interesting, I mean, California has the biggest death row in the country. And one of the reasons that there's been so many findings of death here, in part, is because there's more flexibility than you may think in those aggravating factors. The aggravating factors here, in fact, are broader than in Texas, where I worked for 10 years. In Texas, you have a relatively limited number. Here, things like especially heinous. As a prosecutor, if I look closely enough at any murder, I'm going to find a way to describe it as being especially heinous. Even if it's a spare moment before the person turns and fires a second shot, I can try to convince a jury that that makes that murder especially heinous. And one of the things that we see is an endemic problem with the death penalty is that it puts so much in the hands of prosecutors. So you have a lot of discretion from the start to the finish. But one of them is when you've got somewhat vague language like that, it's going to vary from person to person based on their abilities and their inclination, whether or not they take that opportunity. Other questions?
I really thought your argument about the woman caught in the act of adultery and holding the rock and having a legal right to hold the rock and then making the choice, the moral choice to let the rock go, I thought it was very eloquent and also something I'd never really considered before. But I'm wondering, as jurors, how the law is constructed in a democracy by the people. That the people determine the power that people are going to have to apply the law. But once the law is written, it sounds as if, it feels as if the court is mandating that the law is applied without discretion because it's been written now. But you were asking us, if I'm not mistaken, to actually do what we wanted to do and thought was right, regardless of what the law gave us the authority to do. That's a conflict for a juror. Did you want to make that conflict? And is that what, I guess what I want to ask is that actually legal?
Yeah, that's a great question. Do you want to address that?
That's a hard question. You take it, Mark. Yeah. What that is more than anything is a jury nullification question in most types of cases. And when we use that phrase, kind of a term of art, that means that the jury thinks that the prosecutor met its burden, but doesn't want to convict the person or exact the sentence as allowable. Here it's a little bit tougher because in the death penalty context, the Supreme Court has held that almost any mitigation can be considered, well really any mitigation can be considered by a jury. And so that mercy, if it can attach to something that was said previously, is probably going to be allowable. And so the same way that I said that prosecutors have a lot of discretion and can turn something like, especially heinous around. Defense attorneys sometimes in very good faith will make an argument like that. Because if the jury can hear that, I mean, they won't use a biblical story, but if they can hear that and attach it to something that is mitigating, it will influence them. And that is allowable.
Why wouldn't you use a biblical story like that?
You're going to be prohibited. The court prohibits to enter into biblical stories. One of the sayings that I use in court when I argue my closing arguments is, the only question is whether my clients will die at the hand of God or that of man. And you're here to answer that question. On my last trial, they said you can't say by the hand of God. And I wasn't quite sure. I'm like, well, how do I phrase it then? Because there is always God or man. So, but in terms of what you asked, mercy in California under the law, and I have always argued it, is that you as a juror have the right to say, every aggravating circumstance is true, but me, I will exercise mercy, because that is who I am and what I stand for, and I have never been shut down for that. But you have to understand that in California, the jurors that I argue to are death qualified jurors. There are jurors who have stated that they can impose a death penalty. So if there is anyone out there that says I cannot impose a death penalty or I'm against it, they do not sit on my jurors. They are kicked off the jury.
Yes, sir.
Yes. We just have a couple minutes, and I guess I understand Prop 34 is attempting to remove the death penalty.
Yes.
Would you be willing to just give us your personal opinions about that and why?
So I'll start with you, that's your question.
I support Prop 34. I think the death penalty should be abolished. And I always came from it from a perspective of, I'm a criminal defense attorney. I wanted to do civil rights work, but I had a death verdict a year ago in one of my cases. And it was one of the most devastating things. And it wasn't only for me, it was for my client's family and my client and the victim's family, because they went through this whole ordeal of a trial, of victim impact, reliving it. And for the next 25 years, they're going to be reliving it again and again with every appeals, with everything. And my client in 25 years is going to be a different person than she was then. She actually became a different person for 3 years. And if you guys ever get a chance, Jeanne Woodworth is the warden in San Quentin. She was the warden at the death chamber. She walked people to that chamber, and she is a proponent of the anti-death penalty proposition now. She says she walked many of those people to the death chamber, and they were different people. And she couldn't believe that she was ordered to kill them because they were no longer the people who were in trial. I have seen the impact the death penalty has from what it does to families, what it does to my jurors. My jurors were devastated. They came with a verdict of death, but I think that will always be part of their psyche. It is such a devastating system that we have that there is no discretion. I've had clients who were given life letters. The district attorney said, we're not going to pursue life because your client is willing to snitch out someone. And I've had the district attorney saying, your client should get the death penalty because politically, we really have to go because she's one of the few women who've been accused. It's such a random system. It is no discretion, and it's such a devastating thing to go through. I see no justification for it.
We abolished the death penalty in my home state, Illinois, last year, on March 2011. And Mark Osler was there to help us do that, to talk to people on the governor's staff. Governor Quinn ultimately signed the bill. And one of the wonderful things that has come out of that, of saying we're replacing our death penalty with life without parole, is that because life without parole costs so much less than the death penalty system, that already that money is being plowed into law enforcement to prevent crime and into victim services for people like me who suffered the loss of murder but who may not have the resources I do to deal with, you know, what they may need in terms of counseling and housing and scholarships for dependents of someone whose life has been taken. So already we see the benefits of having gotten rid of our death penalty.
Why does it cost less?
It costs way less because in the death penalty cases, there's two trials. Initially, there's the guilt and innocence trial, and then the much longer trial of the aggravation and mitigation. There's tons of expert witnesses that are paid for by the state, by the taxpayer, about people's, you know, brains and their psychology, and then there's an automatic appeal. So you've got to order all the transcripts, and you know it goes up on appeal because we don't want to just have people go straight from trial to death. Death row is more expensive. It's a different type of guard and a different type of program that you do it. And then just even carrying out executions are extremely expensive. So it isn't just one thing. It's a whole host of things that adds up to, you know, rather than in the hundreds of thousands of dollars to house someone for life, it's in the millions of dollars to kill just one person.
Yeah, well, first, Jeanne's being too modest and saying, like, the entire citizenry of Illinois got rid of the death penalty. She had an awful lot to do with it. In fact, when the governor signed that bill, she got the pen and was there. So she knows what it takes to get rid of the death penalty. I'll say for my part that my problem with the death penalty is of faith. I think that the story that we heard tonight from John 8 is a remarkable thing. I mean, what other social issue that we have before us now did Jesus confront directly? I mean, that was a legal execution. The Pharisees call Jesus over and say, what do you think of this? And essentially what he says is, you don't have the moral authority to do this. You don't have the moral authority to do this, and neither do we today. That is God's decision, whether to take life in that situation. I mean, connected to that, I want to answer a question that we get a lot. We haven't gotten it from you all, but it's the hardest question. That is, are you equating the execution of Jesus to the execution of a murderer? And it's a fair question. And the answer is we are. But we do that at the invitation of Christ. When Christ said, when you visit those in prison, you visit me. He didn't say when you visit the innocent person in prison, or when you visit the political prisoner. It really is him, in a sense. And that's deeply powerful. I mean, when I moved to Texas in 2000, I was so taken by the juxtaposition between this Christianized political culture there and the fervent support for the death penalty, given that at the center of our faith is an unjust execution of an innocent. And what was learned in Illinois was that almost half of the people on death row were actually innocent. They were exonerated. Think about if we're wrong just once. And we have been wrong, at least once. I mean, the odds are pretty far against us never having been wrong. That someone who wasn't guilty of the crime was killed in our name. And this is a point that Jeanne often makes, and it's a wonderful point, is that when someone is executed, when that death warrant is issued, it's not in the name of the prosecutor, it's in your name. It's in the name of the people of the state. And that's one reason that people should care about this particular proposition.
One more?
One more question.
Well, I just have to thank you all so much for being here and letting us do this, and it was just such a joy for us to see the way that you all engaged with the best of yourselves and your hearts and minds. So thank you for being part of this drama, of being the most important part, which is the jury. So thank you very much.
Big round of applause. Thanks for coming today.